Hello, good evening, everyone. I'm attorney Ella Brudner, and I'm coming to you live from Orange County, California. And I'm going to talk today about marriage-based petitions. And it's a big topic, but today specifically, I'm going to talk about marriage-based petitions when the petitioner and the applicant are in the U.S. So it's a kind of specific scenario. For those of you that don't know me, I'm an immigration attorney. My firm, Brudner Law, is located in Southern California in Orange County, and we handle almost all types of immigration cases. We do business immigration, we represent investors, we represent employers, individuals, students, you name it, we probably do it. So if you have a case, if you're interested in starting a case with us, feel free to reach out. We'd love to help you. Also, we serve clients throughout the US and all over the world. So it doesn't really matter where you are, we can help you. And like I mentioned, today I'm going to talk about how to petition your spouse for a green card here in the US. And this topic is very, very important. It's one of our most popular case types. Again, we do a lot of cases, but I think the majority of our cases are family-based cases and marriage-based cases. And I think now is the time to file a marriage-based case if you're eligible. I put up a video yesterday and some links to an article talking about USCIS avoiding furloughing 70% of their workforce. So everyone was a little worried about what's going to happen with immigration. They it's not over. They still have financial troubles, but they were able to avoid laying off 13,000 employees, which would have affected immigration cases tremendously. So everything is good now. Everything is still open. No one is going to be furloughed in immigration. So it is the time to file. Okay. And let's jump right into talking about how to petition your spouse for a green card here in the US. If you have any questions throughout the live presentation, feel free to write them in the comments. And if you're watching this in replay, so it's same thing. Feel free to write a comment or send us a direct message. We will respond when we see it, and we'd love to help you anyway, live or replay. We'd love to help you. So let's jump right into our topic today. So applying for a green card in the US is called adjustment of status. And you might have heard the term. It might sound a little bit familiar to you. A lot of people talk about adjustment of status, and that's just a fancy name. It's just the process, what the process is called here in the US. And it's just the process of applying for a green card when you're here in the US. If you're outside of the US, it's something else. It's called consular processing. So who can adjust their status? The law specifies specific requirements that you need to comply with in order to adjust your status. But here's the thing. Almost all of these requirements have exceptions, and they have ways that you can work around them in some cases. So I'm going to say what the requirements are, but also please remember that this is just really, really general. Okay, so the first requirement to adjust your status, meaning to apply for a green card here in the US, is that you need to be in the US. Okay, that's pretty straightforward. If you're outside of the country, you're not adjusting your status. Something else. You have to be eligible for a green card. Okay, so to be eligible for a green card, you need to have some kind of basis on which you're applying for the green card. Usually it's a petition. Someone's petitioning you. So it's either a family member, and in our case, what we're talking about today is a spouse, or it's an employer that's petitioning you for an employment-based green card. But you have to have some kind of basis to be eligible for the green card. And you need to have the green card available to you right now. So not all green cards are created alike, like they say. Some have a wait. So in certain categories, in certain eligibility categories, there's a wait for a green card. So if your visa is available for you, your priority date is current. For example, you're marrying a US citizen, there's no wait, there's no priority dates. Then you can file to adjust your status in the US. Okay, so you need to be here in the US, you need to have someone to petition you, and you have to have the visa available for you right now. Another requirement is also very generally, okay, you need to have entered with permission. And what does that mean? So you have to be in what's called inspected and paroled. You have to have either come in with a visa or a permission. Okay, some people from certain countries don't need a visa to come to the U.S. For example, from European countries, and they can come in with ESTA, with the visa waiver program, but they're entering with permission. Okay, again, there's exceptions to this. There's cases in which even if you did not enter with permission, you can still apply to adjust your status in the U.S. Okay, just talking general right now. Okay, if you want specific advice, you need to call us and we'll talk specifically about your case. And lastly, the last requirement is that you need to have been maintaining status in the U.S. Okay, one of the biggest exceptions to that is immediate relatives of U.S. citizens. So spouses and minor children and parents of U.S. citizens do not have to be maintaining status in order to apply for their green card in the U.S. or to adjust their status. Okay, so depending on what category you are, if we're talking about spouses right now, you may or may not have to comply with all of these requirements, but those are the requirements for adjustment of status. Okay, and let me see. Let's go in to talk about the next, I want to say, question, very frequent question that we get a lot. What documents do you need for a green card petition? So let's say we have a couple. The petitioner is a U.S. citizen, and the beneficiary or the applicant is a visitor, and he's coming from Europe from somewhere abroad. And they decided to get married, and they're here in the U.S. and they come and they ask me, okay, what do we need? What kind of documents do we need? So most of the documents that you need are listed in the USCIS website, uscis.gov. You can go in and you can check exactly what you need for the green card petition. And I'm going to summarize it. First of all, you need to prove the petitioner needs to prove their immigration status. So if the petitioner is a green card holder, they would need to provide their green card. If they are a citizen, they would either need to provide their birth certificate, their naturalization certificate, if they naturalized, or their U.S. passport. All of those can work for proving U.S. citizenship. Okay, so the first thing, petitioner needs to prove that he can sponsor, he can petition, or she can petition. Next, if we're talking about marriage case, remember, it's just very specific to marriage case today. You need to prove that you're married. So you need to prove the relationship. How do you prove a relationship? Marriage certificate. Very straightforward. You can't get an approval of a green card marriage case without a marriage certificate. Now, if you've been married before, you need to show that the previous marriages have been terminated. Okay, you have to show that if you were divorced, you need to provide a divorce certificate. If you were divorced more than once, this happens a lot. If you were divorced more than once, you need to show a divorce certificate for each of your divorces. Okay, you won't get your marriage case green card approved if you cannot show that you've been legally divorced for every marriage that you've had. Even if you've been issued a recent marriage certificate with your new spouse that you want to petition, even if they gave you a marriage certificate, you won't be able to get your green card if you don't show that every one of your marriages was terminated and there's a divorce certificate. Or in case of a death, then a death certificate. Okay. Next thing you have to show the applicant's identity. We do that with the birth certificate of the applicant. For the first step, for applying, you can use a copy of it, but at the interview, you need to have the original birth certificate, just something to kind of keep in mind. You need to show proof of entry and proof of status. So how do you prove that? You show the stamp on your passport if you entered with a visa. You show your I-94, which you can download from online from the CBP website, and you have to show that you entered with permission, and that's how you do that. In cases where we don't need that, you don't need to show that. And you have to show financial documentation. This is also a lot of people ask me about that because the petitioner also needs to financially sponsor their spouse or the applicant. And they do that by the affidavit of support. They need to show tax returns. They need to show a letter of employment. They need to show W-2s, pay stubs. And if you're not working, then usually you would need a co-sponsor, and then the co-sponsor would have to show all of that. And we would guide you specifically how to do that, what exactly you need for financially, for the financial burden. And also, if you want to check out uscis.gov, you can see all the information there. Right now, there's a huge news going on with the public charge rule. So in February, the administration came out with a new rule for requiring applicants to prove that they won't be a public charge. They need to provide what's called the Declaration of Self-Sufficiency. It's a long form. It's 20 pages, and you need to show a lot of things on it: your debts, your liabilities, your income, your assets, your credit score. You have to show proof of insurance. So fortunately, at the moment, USCIS is accepting cases without all those public charge because this is in litigation right now, and there's a temporary injunction on it. So that's just another reason to apply as soon as possible if you're eligible, because right now, at this moment, there's no requirement for public charge documents, and that can change. Okay. Last but not least, you need to show proof of the bona fide relationship. Okay, remember, we're talking about spouse cases. So marriage case, green card, you have to show that the relationship is real, that you entered, from love. You got married because you loved each other, and it's a real relationship. And you can show that by showing that you have a lot of joint documents. Joint documents are official documents that come from someone else, not from yourself, that have both names on it, the petitioner and the applicant. For example, it could be a lease for an apartment. It could be a mortgage. It could be tax returns. If you are filing jointly and you have both of your names on your tax return, that's a very strong evidence of the bona fide relationship. If you have children together and you have birth certificates with both of your names on it, that's gold. Children together is really good for marriage-based cases. Okay. Other documents, other proof of bona fide relationship that we always submit is pictures of the couple. We say that it's best to send in pictures, about 10 pictures of the couple with other people. Okay, think about pictures that it's hard to kind of fake. So if you're with your family, if you're celebrating holidays, if you're traveling to different places, document it, show pictures of that, write a little label on, Christmas 2019 with our families, and list all the people that are in the picture. Just kind of gives it a more realistic feel to it, okay, to prove the marriage. So that's pretty much the general gist of the documents that you need to file. Every case is a little bit different. This is very, very general. Some cases we would need to file other documents to show different things, but this is just in general what you would need for a marriage case. Okay. So moving on, I want to talk about a couple of scenarios that are very typical scenarios to us, things that we see often. And we're just going to discuss it right now, and I hope it'll be helpful for you guys. So first scenario is the applicant entered the U.S. with a visa and got married to a U.S. citizen or green card holder. And now they want to apply for their green card. Okay, so if you're married to, it's a little bit different if you're married to a U.S. citizen or a green card holder. So let's talk about green card holder first. If you got married to a green card holder, you have a little bit of a less protection. First of all, you're not considered an immediate relative category because the immediate relative is just for U.S. citizens. Okay, so when it's a green card holder petitioner, you need to first check that you have a visa available. You have to go look at the visa bulletin and check the dates and see if a visa is available. Now, for the month of August and for the month of September, that category is current. So if you're married to a green card holder, right now there's no wait. Okay, now is a really good time to file for your adjustment of status if you're eligible. Another thing to take into account if you're married to a green card holder is that you have to be maintaining status. So, came in as a visitor, you have to apply while you're in status. So before your visitor status ends. Okay, so that's a little tricky. So first thing I would ask someone that comes in, got married to a green card holder, when does your status expire? Okay, because you have to be in status. Once you apply to adjust your status, then that's okay. You are now in the process and you're pending your green card. You don't have to stay necessarily in status throughout the whole process, but you need to stay in status when you're applying. Also, if you work without authorization, that's not waived. So that's something that would prevent you from applying. Okay. Some cases when there's issues like that, we do ask or recommend to wait until the petitioner can naturalize and then file for the spouse. Okay. Because if you are married to a US citizen and you entered with a visa, you can apply for your papers for your green card even if you overstayed your visa. Okay. So even if you work without authorization, that's all waived. The spouse of a US citizen is an immediate relative. There's no wait. It's like the golden category. It's pretty straightforward. Okay. So in this case, let's say we're talking about marriage to a US citizen. There's a visa available. They're here in the US. They're eligible because there's a marriage and that's the basis for the green card. So I would recommend for this couple to file a one-step petition. They would file we call it one-step petition. So that means they would file the petition and they would file for adjustment of status and they would file for work authorization and they would file for a travel document. It's a whole packet. And they can file right here in the US and there's no need to leave. And, while the process is pending, the applicant will get work authorization and a social security number. And it's just a matter of time until the couple will be called for an interview here in the US at their local field office. Okay, so that's the first scenario. Okay, the second scenario, which also happens often and we get a lot, is what happens if the applicant entered the US, but this time without a visa. And then they got married to a US citizen or a green card holder. So this is the situation in which one of those requirements for adjustment of status does not exist. And that is the requirement to enter with permission. So if you enter without a visa, that means you entered without permission. You don't have proof of your entry. You don't have a stamp in your passport or on an I-94. In that case, most lawyers would recommend and say that you have to leave the country in order to get your green card. So you would start the process here with just the first petition, the marriage case petition, and then you would have to leave the country and ask for a waiver for your unlawful presence. However, it's really important to note that there is also ways to get you your green card, even if you entered without documents, even if you work without authorization. Okay. And the way to do it, the basis that we do it, and a lot of lawyers don't think about it or don't even ask about it. It's based on what's called marital problems, or if you're in a relationship with a US citizen or a green card holder and the relationship is suffering, it's not a healthy relationship, and the applicant is suffering from cruelty or from abuse from your US citizen spouse or green card holder spouse, you can self-petition. Okay, there's a way to self-petition for your green card here in the US without leaving. And you can file for work authorization, and you can get your social security number, and you can get your green card here in the US without leaving. And that's a self-petition. Okay, and that's for cases of people that are married to a US citizen or a green card holder, or by the way, also if they're divorced from a US citizen or green card holder, and they divorced in the last 2 years. Okay, they're still eligible to self-petition in certain cases. So there are possibilities, and it was important for me today to mention that so that people know, because a lot of people do not know that, do not even know that option. Okay, some people entered without a visa many years ago, sometimes 10, 15 years ago, and they've been married to a U.S. citizen and they have not been in a healthy relationship, and they just don't do the paperwork. They don't want to go. They don't want to leave the country. They don't want to have to ask for a waiver, which is could be risky in some cases. So they just stay put and they don't do anything. So I want to tell you that there is a way to get your papers if you're married to a U.S. citizen, green card holder, or if you've been married to them within the last 2 years. Okay, so if this is something that's relevant to you, feel free to reach out to us. Here's our information, our phone number, our website. You can call, you can text, and we'd love to help you with our case. And another thing that I want to end today with is to urge everyone, if you are eligible to file for a green card based on marriage or based on any other category, you should do it now. Now is the time. Do not wait, because the reason is there's multiple reasons. First of all, October 2nd, all the fees of USCIS are increasing. And I'm going to write it here in bold. File now. Starting October 2nd, fees for green cards are increasing. Fees for almost every petition in immigration. Naturalization, citizenship, they're going up by 80%. We've been doing citizenship applications like crazy the last 2 weeks because no one wants to pay $500 more for their citizenship. Same thing for green card. Starting October 2nd, you're going to have to pay for work authorization and travel document and all those things that are included for free inside your petition right now. They're going to be charged separately. So a whole packet of a green card petition is going to be like $1,000 more, at least, if not more. So go ahead and file now. Contact us. Start your case. I cannot urge you enough. USCIS is open. They're not furloughing anyone. They're going to be going, I want to say full force as much as they can with the backlogs and everything in COVID and everything that's happening. I do urge you to file now. If you have any questions, if you want to talk about your specific case, we love to help you. Feel free to reach out, call, text, email, reach out through our website. And in the meantime, I want to wish you guys a great week. I'm going to be here next Thursday, same day, same time, talking about another topic. Okay, bye guys, stay safe.